Please, are you here? Please stand up for recognition. Caroline, we'll recognize her later on. Lastly, but not the least, we have Chinyere Gladys Obasi, the Welfare Secretary here. Can we all clap for the national officers all here present today? Thank you. Okay, without much ado, I'm going to call on my panelists. We have a very, very interesting session. We heard from the Honorable Justice Bibi Kaim earlier on about election cases being sui generis. And that's really what we'll be talking about now. As we all know, the topic for this session is timely dispensation of justice in election cases and other suits in Nigeria. What is sauce for the goose is sauce for the gander. Basically, what are we talking about here? We know that the Constitution of the Federal Republic of Nigeria has prescribed set lines and timelines for when things should be done, conditions for filing and resolution of disputes in election matters. This, we think, has created a lot of time that's been spent on this case to the detriment of other kinds of suits. Constitutional matters, everything is now put in the back burner because the judges, unfortunately, have to deal with these election cases. And that's what we'll be talking about. I am so fortunate, and we're all fortunate, to have panelists from every sector of the legal services. We have the Honorable Justice from the bench. We have someone from the public sector, someone from the private, a lecturer. So really have a good time. I'm going to start by calling on the chairman of this session, the one and only Justice Ugo, the Justice of the Court of Appeal of Kano State. He is actually representing my Lord Justice Patience Mahmood, because she unfortunately could not be here. So may I please call on my Lord Justice Ugo to please come and chair this session. He's been kind enough to represent my Lord Justice Mahmood, who unfortunately could not be here this afternoon. The next member of this panel is Honorable Justice P.C. Mini, the Judge of Rivers State High Court. My Lord Justice, thank you for coming all the way from Port Harcourt. We truly appreciate you. Our next panelist is my learned brother Silk Yahaya Dan Asabe Dangana, Senior Advocate of Nigeria. Please do join us. Thank you very much, sir. And I have with us Uzain Hassan, the Director for Civil Litigation of Kano State Ministry of Justice. Thank you very much, sir, for joining. Zakiyas Aruna, a lecturer at the Yusuf Maitama State University. Thank you very much for joining. And last but not the least, we have Nancy Obina, who heads the Family Law Subcommittee of the Section on Legal Practice. Are you here, Nancy, to join the panel? There's no seat for you. Wow. I'll get you a seat right now. Please, can you get her a seat? Apologies about that. And so without much ado, I'm going to hand over to the chairman of this session, who will deal with this topic extensively. Thank you, my lord.
Sorry, good afternoon, ladies and gentlemen. Like you have been told by learned SAN. I'm actually standing in. I was supposed to be originally here tomorrow. I was supposed to be here tomorrow, and I was trying to work on what I would say. And then suddenly, late yesterday, I was told by my learned brother that I should be unavoidably absent, so I should come and represent her. So here we are. The topic we have today, for now, I think, let me look at it again. Sorry, gentlemen. Hey, what is that? Oh, no. Sorry. Sorry, it would have been much easier to deal with the one of tomorrow. But this one, I have to keep looking at it again. Timely dispensation of justice in election cases and other suits in Nigeria. What is sauce for the goose is sauce for the gander. I wonder who is the goose and who is the gander here. Whichever way, I think we have an idea. It should be an interesting topic. And I think it is something that agitates anybody who has anything to do with administration of justice. I think I can speak from a personal, probably I'll start from a personal angle. Last year, that is 2023, I hardly sat here. I was here up to the presidential elections, then I went to my place. Then the next thing I heard, I was there getting ready to come back here. Oh, come to Presidential Election Tribunal. That's how I found myself. And I was there from that February or so till about the vacation, the long vacation, when we gave our judgment and I came back here. And I could hardly do anything, and that was the end of the year. But that is not the point. The point is that even before that, there was a time, that was 2022, at the pre-election stage. I was detailed to go to Sokoto to hear a matter. I had bought my ticket and got ready. And then the next thing, they said there was a governorship pre-election matter. And it was thrust on me. 60 days was almost lapsing. Time was against me. I had to carry that big thing with me to Sokoto. I was more interested in that pre-election matter than the one I went for. Sokoto too was pre-election matters. Time was against me. We sat there one day, and I came back. I was working on that file at the airport. On my way down, we got back to Abuja. There was flight delay of 6 hours before we could get to Kano. So I started typing. Thank God that I could type. And I did most of the work at the airport. Of course, I knew that that matter would go to Supreme Court. All the Fagbemis and the Mekiaus and everybody was there. So I had no doubt that this thing was not going to end. Of course, a heated governorship matter. That was the attention I gave to it. But I cannot remember. I've been here at least as a judge. This is 18 years now, 18 years plus. I've never had cause to give the kind of attention I gave to that kind of case in any matter. So, and I remember when we had the presidential election tribunal, when we wrote judgment, Mr. Mahmoud was with us all through. When I wrote judgment for my own contribution, it came to this issue of whether you can front load what they call witness statements that are not front loaded, invalid, blah, blah, blah. to make my point in the little I contributed, in the part I contributed to the lead judgment. I had to make the point that, look, we have to be careful. That it is only election matters, to the best of my knowledge in Nigeria, that has time limit, timelines for disposal. So you have to, as they say in football, keep your eye on the ball. Why can't we do that with other cases? Yes, NJC from time to time tells us that, look, particularly of recent, that our returns must reflect criminal cases. And it is a very important, a very, very valid point. Not only criminal cases to me, but criminal cases are very, very important. Because since I came back this year, if I'm not mistaken, I have, I think, allowed appeals of criminal matters, some sentenced to death, blah, 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 sentenced to death, long sentences. I have overturned not less than 5 to 6 people I honestly believe shouldn't have spent 1 day in prison. But all those ones don't matter. The politicians, they just make laws to favor themselves, and all of us have to just follow up. Should it go on like this? I have also had cause to do cases, civil cases, where commercial matters involving people from other countries, Chinese and whatever, particularly the Chinese, people, our own compatriots will cheat them, will do all kinds of things to them, and then mess up our name. All those ones don't seem to matter. It's all about the political cases. We understand, but should it be that way? That is the issue we have before us. I think, fortunately, like the learned SAN said, we have to share experiences. Experiences not only from us, we're only 5 here. Experiences even from the other side. So let us see how we can do justice to the topic. Time is far against us. I want us to live here in the next, probably not even 1 hour. We should be out of this place in the next 45 minutes. So, I will call on my learned brother from River State to let us give us your own view of it, your own experience. Mr. the Honorable Justice Mina of the River State High Court. Thank you.
Thank you so much. Good evening, distinguished audience. I suppose that we already have the leave to stand on existing protocol, so no need to waste time. My view about this is simple. What are we talking about? Timely dispensation of justice in civil matters and other suits. I would give a nod to the proposition that what is good, what is sauce for the goose is also sauce for the ganders, because if you can't do justice within time that can be said to be reasonable, then there's no justice at all. The politicians, so to speak, have gone ahead to amend the constitution to set timelines within which you dispense with election matters. It's justifiable in my view. That's hinged basically on expediency. Of course, we all know that political offices are tenured, so you have to deal with these things so that people get into their offices and start working. We were aware of the situations with the Edo State elections. I think it was Adams Oshomele's time. We had the Peter Obi case. We also had another one in one of the Southwest where the politicians said, look, it has become imperative for us to set this timeline so that these things finish and then people get into, because there was an argument as to, look, if you pursue election case up to the Supreme Court and then the Supreme Court gives you victory and then the tenure is already half, you should serve only for the tenure that is remaining. And some persons said no. The matter went to the Supreme Court in Peter Obi's case. He said Your tenure begins the day you take the oath of office. So you see that that's the expediency for that legislation. But beyond what the politicians have done, I can assure you, they are not going to legislate for every imaginable case or suit. Let's not deceive ourselves. But we can do something. We can be innovative. We can take the bull by the horn. If rules of court prescribe for when a statement of defense should be filed and served after being served with the writ of summons, for example, and if it says when a reply can be served, why shouldn't the rules of court say when judgment in that matter should be delivered? Why are we shying away from things that are very critical in the administration of justice? It does not offend any law. It does not offend the Constitution. What the Constitution has said, deliver judgment after hearing, deliver judgment within 3 months, or deliver judgment within 90 days. But we're talking about from beginning of the case to the end, including when the Constitution envisages for the delivery of judgment. It means that heads of courts can do quite a lot. We have the instrumentality of practice direction. Heads of court can issue practice directions to ensure that certain matters have concluded within specified time. I give you an example of what has happened in Rivers State. I don't know if that's the case in other states. There's what we call small claims court. That's novel. About 2 years ago, the current CJ issued a practice direction whereby certain magistrates were designated as small claims magistrates to man those courts. And I tell you, from, of course, small claims court, small claims was defined to mean the one within 5 million naira. So you don't need to go and bother the High Court. What you do, you can be represented by a lawyer. You can do it on your own. You fill certain forms, and from the point where that matter is filed to the time of judgment must be within 60 days. Nobody quarrels about it. It does not offend anything. That's an example, drawing an inspiration from what the politicians have done in amending Section 285 of the Constitution to say that election cases must be determined within specified time. So we have to draw inspirations, and escalate it to all of the other cases that come before us. We cannot just sit down and fold our hands and say, oh, National Assembly, you have legislated for election matters. Legislate for us. If they do, it's fine. But if they don't do, what do? We cannot keep quiet. We have to do something on our own. And then I also am concerned about attitudinal change. We need to change. As members of the bench, we need to keep our feet on the ground to say, this matter, I will finish it within. I understand the dictates of fair hearing. I understand the point that, oh, you're going to be hearing from all parties. You're going to be hearing all manner of applications. But there has to be a limit to all of that. Whilst I was in practice, I filed a case, and the judge told us, look, I'm determined to finish this matter in 10, 11, 12 months. Lawyers in the matters, can you help? I undertook. The other lawyer undertook. And before you know it, it's a land matter. Of course, you know, in Rivers State, those are some of the things we do, land problems that can last for 5, 10 years. But we finished that matter in 11 months. That attitude, that approach, everything must not be legislated. If we imbibe the approach, the attitude that justice delayed is justice denied, and we must give justice, we must dispense justice within reasonable time. The keynote speaker talked about Section 36 and reasonable time. We probably are not even thinking about it. We are not looking in that direction. It's us. We have to do these things the way it will, we're not going to be 100% reliant on the politicians. If they legislate, fine. If they don't legislate, we have to do our own. And again, I must say, some of my registrars have told me, my lord, lawyers are saying that you should slow down. And we will laugh about it. That speaks to a pervading attitude of lawyers in not wanting matters to go fast. I don't know for what reason, but that's the truth. So what it means is that we have to have a paradigm shift if we must deal squarely with this issue of delayed justice. There's no way a delayed justice can speak well of us as a profession. I agree that matters are suffering because presiding judges are brought to the election tribunals, and then they would have to abandon those cases and then face the election matters because of timeline. We have to be innovative. We have to think outside the box and say, look, when these judges, if for matters that haven't gone anywhere, they can be reassigned immediately with a matching order by the head of court. I said, look, this judge has gone for tribunal. You take these matters, ensure, like I said, by means of practice directions, those matters can be dealt with. So we cannot always wait and then we cry, why are you legislating for election? Why are you not legislating for other cases? If a judge says, this matter before me, I'm going to finish it in the next 1 year, you penalize lawyers. Thankfully, Supreme Court has started to put heavy costs on errant lawyers. I mean, we can borrow a leaf from there. That's they are the organ at the top. So if they do it, why can't we do it? If we see a lawyer, it's written over the lawyer's face. Lawyers who don't want matters to go on, it's written all over. Do you know that over about 80 to 90% of cases where matters don't go on, it's not the litigant, it's either the judge or the lawyers. So we can penalize lawyers heavily, I must say. Penalize lawyers for delaying cases. We can't continue to go on and then every day, since I became a member of this profession, this particular topic, we've said it again and again and we have to be tired of talking about it and make progress. Thank you very much.
Thank you, gentlemen. Well spoken. We have how many more? 1, 2, 3, 4. Gentlemen, we have to time ourselves before our audience will time us out. We'll end up speaking to ourselves. So please let us be strict. 10 minutes per person. And I will be happy if you can make it even less than 10. You get credit for that. So I give the mic to the learned senior advocate to give us their perspective from the bar. They are the ones that always get first on and put the cases down or make them run fast. So to my brother on my right.
Thank you, my lord. The chairman of the occasion, distinguished conferees, it's my pleasure to share these few lines of experience with you in this ongoing conference. Before the coming into effect of the Electoral Act 2010, which timed the hearing of petition and pre-election matters as well, there were attempts to introduce time, but it did not succeed because of the existence of Section 36 of the Constitution that says parties be given opportunity to present their cases within reasonable time. First, it was Bauchi State Local Government Law of 2008 that timed the hearing of local government petition to 60 days. And when petitions were filed, I was there for the Bauchi State Electoral Commission. The petitioners did not see it coming, and they never went to High Court until the very last day, the 60th day, they now file an action challenging the provision of the electoral local government law on account that it violates Section 36 of the Constitution. And before you know it, the petition wound itself up. The cases of Ngige and Obi that was decided 3 years into the term opened everybody's eye to the need to have election petition determined within a specified period of time. And that was also contained in Uwe's recommendation. As such, the National Assembly, when making proposal for amendment in the 2010 Electoral Act, now brought in this issue of time. We can now see that the underpinning philosophy of it is to guard against endless periods in hearing or determination of election petition. Now that it is here with us and we will need to live with it, the question is, has the underpinning philosophy been achieved? Cases were filed and determined on the basis of 180 days, 60 days on appeal, and others, without making recourse to other factors, particularly on the part of the judges or the justices. My lords, at the Court of Appeal, in the last election cycle, you witnessed a situation whereby, after the delivering of judgment at the trial court, filing of appeal, transmission of records, exchange of briefs, all within the 60 days. And by the time the appeal is ripe for hearing, you have barely 7 days to deliver judgment, to hear and deliver judgment. For crying loud, what qualitative judgment can be delivered within 7 days? Written, well written and delivered. This accounts for why, with the greatest respect, if we pick the law reports today to read the quality of the judgment compared to what was in operation, because the timing is very short, the reasoning and every other thing has no time within which to be well thought of. The judgments are written mostly under pressure. And even in a situation whereby a judge will write, I agree, in the past, you could see that they will write, I have the privilege of writing in draft. The judgment just delivered by my learned brother XYZ. And for this reason, I'm agreeing with him. Here, they will just write, I agree. For me, that is an agreement in protest because they are acting under pressure. So, because we want our cases determined timeously, we are not combining speed and accuracy as the accountants do. So we've sacrificed the substance of the judgment in most cases because we want timeous determination of this. This is one factor that we also need to look at it. On the issue of retrial, because the timing is there, 180 days, 60 days, particularly from the trial. At the time that the judgment is delivered, an appeal filed before the Court of Appeal or the Supreme Court, the court could determine that, well, this judgment is wrong, or for XYZ, the case ordinarily should be sent back for retrial, but 180 days is spent. What has that occasioned? Injustice, but a constitutional injustice, I must call it. Unlike in the civil matter, like the case of Oji Uzo Kalu versus FRN, where it was discovered that the judge who delivered the judgment was elevated, whatever, they sent it back for trial. Why not same for election? Because of the time. Now put all this together, juxtapose it with our normal cases in the civil course. Are these cases dispensed with timeously as it is? The answer is no. And what is the effect of that on the national economy? We have cases of the Ministry of Trade and Investment, Ministry of Agri, and others going to source for foreign investors or foreign direct investments. Under what environment are they coming to invest? The environment that is hostile, that the laws are not investment friendly. A case that could be instituted before determination of the case, it could take years. I was sharing experience with a friend from Canada. He started a case here before he got married and relocated. It is now that the case is getting to Supreme Court. The daughter that he gave birth to The year he filed that case, she's now 16 years and will be writing, she's writing writing WAEC now, SSCE. And it is at this point that the respondents are coming forward to say, okay, let's settle. But in settling, XYZ would. These are investment, petroleum law, oil and gas. So the investors will not be willing to come and invest their money in a situation like this. What is the way forward? Must we wait for the National Assembly to enact law for every sector of our areas of practice? No. My law talked about attitudinal change. If we must wait for the enactment of law in every sector, let me cite 2 examples. We have fundamental right enforcement procedures. We have AGJA. Tell me one case that has been determined within the stipulated period, within the stipulated time provided for under this procedure, either AGJA or FREP. None. So it means we are catching on certain procedure to also further delay the course of the hearing and determination of our cases. A situation whereby a lawyer will come to court, having been served with process, a day or 2 days later, he has a day more to file. The past 6 days you did not file. You are telling the court that, my lord, I'm still within time. If you have not filed within the past 6 days, is it the next 1 day that you will file? So certainly we need to look inward. And also part of the change will be from our judges. The indulgence that is being given to lawyers seeking for adjournment is one thing that should also be looked into. Unless and until we are able to see all this together and find the underpinning philosophy of why cases go to court, our cases will continue to linger. We'll send out the investors that are already in. We'll take the little resources we have to look out for them by organizing investment summits, organizing trade fair, organizing that. We'll spend our money and they will not come because our laws are not investment friendly. I think in this respect that what is source for the goods is also source for the gander with respect to the rest of our cases. Thank you very much, Mr. Chairman.
Thank you. Well spoken. Well, very, very well spoken. Let me just say something before I give the mic to my sister on the extreme right, on my extreme right. The learned SAN spoke about judgments that we sometimes write, I agree, and we are not expansive when you are supporting judgment unless you are dissenting. You see, sometimes it's the same volume of work. If you have too much volume of work, sometimes you just can't afford to. It is far better, like you said. But then, I have to mention again, that before we came to where we are in our judicial system, judgments used to be written by just one judge, even at the Supreme Court. And when I say this, I mean it. Because before I came, at least I had 1970 All Nigeria Law Reports, Volume 1 All Nigeria Law Reports. And I'd read like 5 of them this morning. 5 judgments this morning just to enrich myself before I came. And all those Supreme Court judgments were written by one person. There was not even, the second person doesn't even say, I agree. They agree on one judgment, and that is it. Now, these days, what do you see with the innovations we are making? You will see, like some lawyers will point out, a judgment will run to 90 pages and all that. Those judgments were not any less comprehensible than what we write today. They are not any much more binding. And if you ask me, they are even, with all due respect, better written than what we are doing today. It is like that. So why should we? I don't see serious problem about one writing and the others agreeing. We must always be conscious of time. You have all the time to write your address, but when it starts 90 from the address, from the day of address, the judge is timed. So you can see his problem. Thank you so much. I just wanted to make that point. And then to my learned sister, 10 minutes maximum. Thank you.
Thank you very much. I would like to stand on the existing platform protocols. My understanding of this topic is that election cases do come. Okay, it's good. My understanding is that election cases, petitions do come up, and when they do, like the chair of this panel has said, priority is given, a lot of priority is given to these cases. And this is mostly because election petitions have a way of, the entire system, the democratic system of the country is hinged upon them. And also the will of the people as well is hinged upon those election petitions. But then the question is, should these petition cases be given more priority over the regular cases that are being handled in the regular courts? And this is because during election petition, or when we have the tribunals that are set up, we do have scarcity of judges, and we also have paucity of lawyers. Everything stops. And I think each and every one of us here that is practicing is a victim of this situation where you have cases ongoing, but unfortunately the courts have been shut down because the judges are not available anymore. They're on election petition. And also the lawyers have also moved to other parts of the country. So should this be the case? Should this situation be upheld and given more priority than, for instance, a criminal case, where criminal cases, lives are matters, serious stake, and properties as well in civil cases? Like I've had cases that I had to stop, and the accused persons at some point in time when I was a prosecutor here in Kano State, and they were not really on bail, and then the case dragged on for years and years, and that was one thing that even on appeal, the defense counsel had to attack me on, that from the time of taking my first witness to the time that I was able to bring my second witness to take him, it took a period of almost 1 year. And so the prosecution did not diligently prosecute the case. But then what was the point that was missing in that allegation is that the judge was not around and that everything had to stop. It was something that was beyond my own control. Should we give election petitions priority? If I'm to answer this question, I would ask one more question, like I'm a typical Nigerian. You ask a question, I will answer it with a question. Ted will become the person that will be the person that will come into office. And if this person that comes into office will, now if we have that, my answer will be yes, please. But in a situation in a country like Nigeria where we have system collapse, institutional failure, people are suffering, I will beg to say, please don't take the judiciary the common man. So for me, if the executive and the legislature should fail, the last thing that should fail is just the simple truth. And like my Lord here, Justice Kanyip said earlier in the morning, is saying that like me and everyone here who are not politically incentivized, they are regular people having their cases will put their lives on hold. Every person that goes to court or every person that has a litigation or a matter before the court takes his litigation as seriously as he can, and that is subjective. So should that not be given enough priority? If a person or a witness will leave everything that he's doing to come and spend the entire day so that his matter will be heard, just so that he gets justice, then should that be denied? Ultimately, when we close down all of our courts because we want to hear election petition, it simply means that access to justice of these people is being denied, and that affects their fundamental rights as enshrined in Section 4 of our Constitution. So, for me, what is source for the goods is also source for the gander. If election petitions are going to be given this priority, then ordinary cases in regular courts, everyday courts, should be given that much priority as well. But then the question is, how? How do we do that? How do we rank these cases to be in pari passu with each other without one trampling on the right of the other? Because each one of them obviously is very important. When you talk about petition, election petition, it means the right of somebody who has petitioned that his election has been controverted or has been trampled upon. he also has a right, like you said. It could take like 3 years before the real person that has won the election to take office, because there's been a long legal battle ensuing. So at the end of the day, there's no justice for him. And at the end of the day as well, there's no justice for these regular people, ordinary people like myself who go to court. I've seen witnesses who sell their cattle in the rural areas just to come to court because we don't have enough money, for instance, from the Ministry of Justice all the time to pay for witness fees. And these are people losing value every day. So their case are as important as the industrial court. We could save the situation. And a Supreme Court justice from that. And also, like my Lord Justice from Port Harcourt, he said practice directions could be used. Yes, and I agree to that as well. Practice directions could be a very useful tool that we could have. We don't have to wait for legislature all the time to make large the jurisdiction of these magistrate courts. Then they would be able to take on capital offenses just for this time limit of the petition until all is done and settled. They could take over, they could handle capital offenses like homicide, like robbery, like rape cases. And although prioritizing the cases as well is very important, all cases that are not, for state councils, for instance, all the cases in the High Court so that we could decongest them. And also at the same time, you make use, during this period of time that are very critical, please make use of alternative disputes resolutions. When you know the judges are going on election petition or they're already gone, instead of putting your case to wait for a very long period of time, why don't you use mediation? Why don't you resort to... So for every lawyer that is practicing, it is very important, doesn't have any basic...
Rich and well thought out. Let us hear from the Ministry of Justice. Let us hear from the ministries. They are working out on us. Please let us finish it as fast as we can. Probably next time when we come, I shouldn't be coming when people have eaten and heavy. Thank you.
I believe the mic is working. Good afternoon, ladies and gentlemen. My name is Hussein Hassan. 285 aims results. And it also, secondly, it discourages frivolous litigation. Election petition being a serious business, you have to gather enough data, reliable data, to establish your case before a court. So you will find out that because of the timeline, most people who don't have genuine cases don't have enough time to gather frivolous cases to present to the court. That's on that. And it also promotes electoral stability. As in, whenever there is an election, there's always a winner and a loser. So the loser always anticipates what the outcome of the court will be. Like, example in Kano State, this present dispensation got their judgment at the Supreme Court. So you see, it has also that advantage. Among the demerits, because actually it's a double-edged sword. It has advantages and it has disadvantages. Certain cases are really complex. They require time. That when you rush a case, it might, just like my Lord has stated, he was writing judgment in the airport. It will not give him ample time to do justice to the documents that are attended before his court. Maybe all the exhibits, he will not have time to do that because he cannot carry them along. That on that note again. Then the timeline also among the demerits we can consider is it discourages settlement. We have seen cases where election petitions are withdrawn because of a timeline, a speed timeline. It's going to reduce, definitely it can reduce, has a tendency to reduce timeline negotiation. Then other additional considerations that can be considered are like on effective implementation. Actual effective implementation depends on the capacity of the court to meet the deadlines. Then there is also issue of balance between speed and fairness. You have to balance. Once time is running, the rate and the quality of judgment definitely will be affected because of you have to balance time with timeline. You have to balance balance the two, time and justice. So, and finally, what can we do to alternative approaches in other dispensations? I, coming from the public bar, I have experiences. Like if you consider fundamental right enforcement rules, we have the FREP rules provide time in which you have to file your processes. You have 5 days. Under the Federal High Court, once you are out of time, there are penalties. These penalties, 1,000 naira that is paid, actually has the ability to make councils to set up. You find out that unlike in the High Court, you are served with enforcement of fundamental right, you are out of time, you can take 30 days, you will not mind. But once it's in the Federal High Court, even members from the public bar have to pay default penalty. Likewise, in the National Industrial Court, it's 200 naira. Unlike in the Federal High Court, in the National Industrial Court, it's 200 naira per day for the first week, then 100 naira for the first week, then subsequently it's 100 naira per day. So this has the ability to make council